So, my lords, my lady, I'm on the Respondent's primary case, which is hewing to the Mr. Justice Leggett analysis in Rahmatullah, in which I explained yesterday there are going to be two parts of that analysis. First, looking at the narrow Act of State doctrine, and then looking at justiciability. And I'm going to address first, if I may, the narrow Act of State doctrine, to try and show that it's no more than a rule of English private international law that presumes foreign laws expropriating land, property or possessions are to be taken as valid by our courts. That not only applies precisely the same analytical framework as general rules of choice of law, but shares, at least in modern times, the same principal justification, namely the recognition of the legislative sovereignty of foreign states within their own territory. It's been applied exclusively in this country in the context of property and assets. A useful starting point for identifying the division between the narrow Act of State doctrine and wider principles of justiciability is, of course, founded in Lord Wilberforce's speech in Buttes, and I wonder if we could just briefly turn that up. It's Volume 1, Tab 8, MS 1746. And if we could turn to page 931 at 1789.
Yep.
So, of course, the court's seen this many times, and I'll take this, as with other authorities today, with a little speed, if I may. But his lordship turns to this narrow Act of State doctrine just below letter A, which is the second version, the non-Crown Act of State version, consisting of those cases concerned with the applicability of foreign municipal legislation with their own territory and with the examinability of such legislation, often but not invariably arising in cases of confiscation of property. And there cites three cases, Carr, Luther and Princess Olga. His lordship notes that 2 points were taken in respect of that. Firstly, it was said that legislation can be called into question where it's contrary to international law or public policy, and secondly, it's only recognised within its own territory. It's worth just examining why his lordship rejected that first contention, because it gives us a very helpful insight, we would submit, into what his lordship then understood later on in his speech non-justiciability meant. So just above D, As to the first point, I pointed out the attack on the decree is not upon the validity under the law of Sharjah, but upon its efficacy in international law. But this brings it at once into the area of international dispute. It's one thing to assert that effect will not be given to a foreign municipal law or executive act if it's contrary to public policy or international law, and quite another to claim that the courts may examine a validity under international law or some doctrine of public policy of acts operating in the area of transactions between states. Now, that is something I'm going to return to later when we seek to examine what Lord Wilberforce did mean in this later category of non-justiciability. It's not a case, it doesn't apply if the case is concerning municipal law. It applies when you're focusing on transactions of the international plane. But that's not this narrow doctrine.
Does Helmut Wag help us at all?
It does. I'm going to show, my lord and my lady, in a moment, a passage from the judgment of Mr. Justice Upjohn, as he then was, which helps us understand the rationale behind this narrow Act of State doctrine, which we're going to submit is no more than a choice of law rule.
Yep.
The second argument was dismissed because, of course, in that case, the whole issue was whether or not the concession fell inside or outside the territory. And his lordship then, in the final paragraph on this page, draws the distinction. The essential question is whether, apart from those particular rules, so those rules didn't apply to this case, there exists a wider transaction. And his lordship would have preferred to avoid an argument on terminology, but he says it's something different. The Act of State that he's just identified under the Luther and Sager category is something different to what he's then going to turn to. Can I deal briefly with the first two cases of the three that his lordship dealt with? Carr and Frackis, Volume 9, Tab 73, MS 4612.
Thank you.
This was a claim for conversion against the commander of a British Navy ship which seized ammunition from a boat within the territorial waters and therefore within the jurisdiction of Muscat.
Yep.
The defendant sought to rely upon three documents. Firstly, a certificate from the Secretary of State for Foreign Affairs certifying that Muscat was a sovereign state and the Sultan its sovereign. Secondly, a proclamation by the Sultan that British vessels of war could stop vessels in its territorial waters and seize goods. And thirdly, a certificate from the Sultan's court that the actual seizure in this case was lawful and therefore in accordance with the proclamation. And the speeches of their lordships show that this was a case all about the application of foreign law, because although Muscat wasn't a democracy, it was nevertheless had a legal system, and that which the Sultan proclaimed was the law and would therefore be applied on a conflict principles. Can I just identify, not ask you to read at this stage, but just identify where you find that? We can start in the speech of the Earl of Halsbury at 4615.
Right.
If you could just mark the key passages, second paragraph, over halfway down, the broad and simple proposition is that
well, the one which begins, "It is said forsooth."
It is said forsooth, and you can pick up the key, the key passage. If you start,
My
the
Lord.
broad and simple proposition is the Sultan has authority, just
Right.
at the end of that paragraph. Lord Macnaghten, page 4619.
Yep.
And it's the last paragraph in his speech, starting the respondents contend.
Yep.
Lord Shandon, Lord Brampton agree. You can see that at the bottom of that
Yep.
page. Lord Lindley at 4620, starting last paragraph, no evidence
Yep.
was given to show, just to the end of that paragraph, at the beginning of the following page.
Can you just draw attention to the in fact,
Yes,
just after it is said forsooth.
just if we go back to the Earl of Halsbury, if you could read the whole paragraph from it after it is said forsooth.
Including the questions.
Including the questions, yeah.
Yeah.
So that's Carr and Fracas. It is a case, it's a conflict of laws case. The same can be said of Luther and Sagal. It's a case that's well known. Can I just give you, again, if we can just look at the report so you can flag up. You'll find that in 971, 4573.
Thank you. Yep.
Lord Justice Banks, 4586. Relevant passage, starting from the top, it is necessary. If you could just go to about halfway down before in Santos and Illage.
Right. Yep.
And then over the page at 4587, about 7 lines down, a line starting, even if it was open to the court to this country, to the end of that paragraph.
Thank you.
Lord Justice Warrington, 4590.
Yep.
Well,
Passage starting, some paragraph starting, some reliance was placed by the respondents. That paragraph.
Yep.
Lord Justice Scrutton, 4598.
Thank you.
Right at the bottom of the page, it remains to consider the argument,
Yep.
and then really to the end of his judgment.
Thank
sorry,
you.
what was the last one? It was
Bottom of 4598. Last 2 lines to the end of the judgment. Yep. Thank you.
Now, just for your notes, there is a reference in 2 of the judgments of their lordships to the United States case of Underhill and Hernandez, which is, of course, a case in which it is often said is the foundation, or at least one of the foundation stones of the Foreign Act of State doctrine. Just for your note, you'll see Lord Justice Banks dealing with that at page 542 of the report. Halfway down, page 4583.
reference to urchin as well.
Yes.
Yep.
And with Lord Justice Scruton at page 4598.
Yep.
And the point that we make there is that's not in respect of foreign act of state doctrine.
Same three cases, yep.
That is simply in respect of whether or not the courts should recognise as sovereign a revolutionary government
Yeah, I see.
that has been recognised by our own. So it's not being relied on in those cases for any wider principle.
Yep.
Can I then move?
How do you deal with the fact that in this case they seem to have rebutted the idea that you could investigate the morality of the foreign law or seizure?
Well, because my Lord, today that would be simply understood as the application of Section 14 of the Private International Law Miscellaneous Provisions Act. So, as I'll go on to explain in a moment, these cases can't be read with a modern eye as saying you can never not go behind a foreign confiscation. And indeed, I'll show you some passages that show some exceptions that are well recognised. But today, as I'm going to go and develop in a moment, all these cases would be readily understood under our conflict of laws framework, under the 1995 Act. Could I move to Princess Paleolga, because that is an authority that's relied on for support of a wider proposition. You'll find that at tab 69.
Same bundle, right, thank you.
Same bundle, at
We've
4514.
We've looked at this
We looked at this very briefly.
briefly, yeah.
My Lord.
Yep. You want to look at it a bit more
I
carefully.
want to look at it with a little more care,
Okay.
although with this caveat. It's a very difficult case to follow. And that is not least for the reasons given by the court in that case, that it was faced with great difficulty in understanding what the law in place in post-revolutionary Russia was at the time. But it nevertheless identified two decrees rendering lawful the expropriation of the property, and a constitutional provision, and a rule of their civil code. Now, the complexities facing the court in this case are referred to by Lord Justice Sankey in his judgment, which we can see at 4526.
Yep. Yep.
I needn't take you to it, but just so you can mark, agreeing as I do with the learned judge, he then goes on to talk about the great difficulties in the case.
Yes.
But the core of this case is, again, a classic conflict of laws case. The relevant decrees were identified, and the court said we're not going to go behind them. We're going to recognise the legislative sovereignty of the new Russian state. Now, we can see that in the judgments of all three of their lordships. Can we start in the judgment of Lord Justice Scruton at page 722, MS 4518.
Yeah.
It's a passage starting just, it makes more sense if we start just before the end of the first main paragraph.
Yeah, I understand.
The Russian government had in the contract of scale described the property as nationalised property.
Yeah.
And then you'll see at the beginning of the next paragraph, they did so for two reasons, which the judge has held to be valid. And those two reasons are two different decrees. So if perhaps the court could just mark those paragraphs over the page.
Yes.
To 723, so about halfway down the first main paragraph, starting the second title.
Yes.
And mark conflict of laws. And you can see a summary of that in the judgment of Lord Justice Scruton. If we turn to the very last paragraph of his judgment.
Scruton, not Scruton.
I'm so sorry.
Correct.
Scruton. At 4521.
He would have been much ruder. Don't worry.
I have no doubt. At 4521.
How do you know?
Because he was a very rude man. Yep.
Robust.
He's good golf.
In his terms, robust. In our terms, rude. Yep.
I don't go more minutely into the decrees and evidence in this case.
I never met him, I should say. Sorry, do continue.
That was why I was asking how you knew.
Yes.
I substantially agree with the careful judgment of the first instance judge. Our government has recognised the present Russian government as the de jure government of Russia, and our courts are bound to give effect to the laws and acts of that government insofar as they relate to property within that jurisdiction, when it was affected by the laws and those acts. A similar conflict of law analysis is applied by Lord Justice Sankey at 4527.
Yeah.
And we can pick that up about 5 lines before the end of the first paragraph, where his lordship says, I agree with the judge.
Yes.
He says, I'm constrained. Could you just again...
Conflict of laws. You want?
Conflict of laws
Okay.
to the end of that judgment.
Point taken. Yep. Thank you.
And Lord Justice Russell at 4530...
Yeah.
we can just towards the end of the third paragraph, starting, the result is that these chattels being recognised as state property, and then it's all the way through to almost the end of 4531, application to the owners of property nationalised under 111.
Yeah.
So classic conflict of laws. Now, there is discussion of a broader notion of acts of state in this case, but it appears, again, to be based upon legislative provisions of the Russian state. And if we could pick that up to begin with in the analysis of Lord Justice Scruton at 4519.
Yes.
And there his lordship notes a third defence, which the trial judge had rejected, but which his lordship thought should succeed. Counsel for the defendants put at the forefront of the argument below and before us that the seizure of property began without legal justification or only by revolutionary right. It was ultimately adopted by the government, which was recognised by the British government as the lawful government of the territory in which the property was, and that this was an act of state, into the validity of which this court wouldn't inquire. Now, his lordship then went on to note, incidentally, that's not incidental to his lordship's subsequent analysis, it was incidental to the judge below.
Yeah.
He referred to the decrees of May 1922 and or to note 1 of the Civil Code of 1923, by which, when by a change of policy the Russian government recognised to some extent private as opposed to state property, they yet prevented the original owner from asserting his original right against those who had by force or revolutionary right dispossessed him. The subsection reads as follows: owners whose property was expropriated in virtue of the revolutionary right or generally passed into possession of the labouring classes or toilers before May 1922 have no right to claim the return of such property. The learned judge dealt with this rather summarily. He thought it was a bad point. I regret the learned judge did not indicate more precisely what it was a bad point. I think it was a good one. And then his lordship goes on. I'm sorry, I haven't missed anything deliberately. As it was based on 3 decisions of the United States, all of which I'm going to take you to, and Luther, which we've just looked at. I regret the learned judge didn't indicate more precisely why he thought it was a bad point. I think it's a good one. And then his lordship goes on to cite Oatgen in the US Supreme Court, which is predominantly about the recognition, and the citation is predominantly about the recognition of a revolutionary government by our government. And then goes on...
Is that right? I mean, I'm not sure. I think in Luther and Sagor and in this case, what they were saying was those cases are authority for a proposition that the acts of a revolutionary government are to be taken as valid. In other words, it's not just... what was a revolutionary government, which ought to be recognised by the British courts, was the second point in Luther and Sagor, which these cases weren't cited on.
Well, my Lord, as I sought to show by the references, and I hope fairly, in Luther and Sagor, both to the conflict of laws analysis and as to the discussion of Underhill and Fernandez, is that the decision in Luther is about the application of foreign law.
Yes, it may be. The
now-
two seem to be a bit muddled up.
Well, there is a muddle, but underlying that is the recognition by the courts that even though these are laws passed by a revolutionary government, it's a revolutionary government that is now recognised by the United Kingdom, and therefore its laws are to be recognised as sovereign laws. It doesn't really go any further than that.
Refreshing.
So what we see in this judgment is an analysis of act of state that is nevertheless premised upon the Russian Civil Code.
Yes.
So it is still, in that sense, a classic conflict of laws analysis.
Understand.
And we see the same in the judgment of Lord Justice Sankey, which begins at page 726 of the report.
4522, yeah.
522.
Yep. Yep.
And his lordship dealt with act of state first, and we just see that about a third way down
Yes.
the page with the first act of state. And then his lordship delves into the the note of the cross-examination of the plaintiff. Over the page, 4523, he then deals with a decree of 1918, noting it had no legislative effect, but in fact the occupation of the house was a seizure by the state. And then his lordship goes into another part of the shorthand note. Now, he doesn't, unfortunately, identify who these are questions from, but it must be an expert in foreign law and looks at the context, at the content of the foreign law. And what he identifies there is evidence that the property was taken under the Constitution. And I wonder if we could pick that up, about 5 lines down. Question: it would appear to be a taking by some authority, either self-constituted or not. Answer: it was more than self-constituted. It was an authority provided by the Constitution of that time. Question: at any rate, it was a de facto power and authority at that time, whatever else is clear. Answer: yes. And then you can see that the judge intervenes. Let me follow that. You say it was more than a self-constituted authority. It was an authority provided by the Constitution. Answer: yes. Then, having set out that as the basis for his analysis of act of state, so a constitutional power, which is the property, his lordship then turns to the American cases, and indeed Luther and Sagor, starting with Oatgen. He then sets out in some detail Oatgen.
Yeah.
And concludes at 4525 that the act of seizure in question was of a government that's been in power and recognised. In addition to this fact, the Soviet government kept control of its goods.
But I mean, it's quite clear that he says on 4524 that the American position is the same as the English in his view. About 8 lines up from the
Yes.
bottom. And the proposition which we get at the top of 4525 is the general proposition that courts of one country won't sit in judgment on the acts of the government of another done within its own territory.
Yes, but, and what I'm going to seek to develop, my lord, is that what you cannot do is take that clause and create an extraordinarily broad rule that means you can't ever judge acts of a foreign government. And that is not what it's being relied upon here. This is being relied upon in a section in which the court has identified a constitutional provision in Russia and essentially giving effect to it. And the context is, should we even recognise these laws as sovereign? And that is primarily what Oatgen is looking at, and that's primarily what Underhill looked at, which is when you have a revolutionary government, are you in a conflict of laws territory? Because are you dealing with sovereign legislation? And the answer provided Luther and Sagor, by the US Supreme Court in Underhill, and then in Oatgen is yes, you are. If your own government, if the government of the court has recognised that foreign revolutionary government as the government, then you're going to record its sovereign acts as if it were any other sovereign legislation. You're going to deal with it under your private law framework. And that's all that's being said there. And although this is a complicated case to understand in the sense that we're not given many clues to interpret it, it's absolutely clear in both those judgments I've shown you that when it's talking about a foreign act of state, it is doing so on the premise that there is a law that is relevant. You get a broader analysis of it.
Well, is that right? I mean, if you look at Lord Justice Sankey's summary of the 3 points at the top of page 4522, it seems the second and third points rely on specific laws.
Yes.
The first point simply relies that the seizure was an act of state.
Well, my lord, that's why I took you to the cross-examination, or perhaps it was examination in chief of the expert that's recorded at 4524, which is all. This is all part of the first part. This is all part of act of state in the judgment of Lord Justice Sankey. And there, what his lordship obviously feels is relevant, because he's setting out the citation, is the fact that it was done under constitutional power. And that's separate to the decrees that he then identifies in his passage.
Done under constitutional power?
Sorry, my lord.
The authority, he's not saying that there was a power under the Constitution, he's just saying that, the Soviet, or whoever was in charge of Russia at that time, the Northern Committee, was an authority provided by, well, the Constitution which they'd presumably announced themselves of July 1918.
Otherwise, what does the first point add to the second and third?
Well,
it must be a different point, because the judge below rejected it wrongly.
My lord, through modern eyes, as I'm going to seek to develop by looking at how these cases have been read by courts, it actually adds nothing.
Well,
Other than the principle that you must recognise as sovereign a revolutionary government that's recognised by your own government.
I have some difficulty with that, because the judge rejected the first point. If he hadn't accepted the revolutionary government was a government, he would have rejected the second and third points as well, because it was a revolutionary government that passed them.
Well, my lord, trying to give absolute clarity and to look to this case for absolute clarity as to what of act of state is actually an impossible task.
Well, it's a pretty strong court. Yeah.
Well,
say that about it.
The Lord Wilberforce also talks about executive acts, and ultimately the question is whether this is a maintainable legal position, or whether it ought to be qualified. I think to suggest that it hasn't been accepted in any authority as a statement of principle seems to be going rather far, and this one seems to be directly on the point.
My lord, I don't put it that high. I just say that properly understood, it doesn't take the matter any further than a private international law conflicts analysis.
Anything else you want to take us to in this case?
Well, I should show you Lord Justice Russell.
Thank you.
Which is a broader proposition, and you will find that at 4532.
Thank you.
A third ground.
Yes.
Is the act of state point, clearly establishes the seizure of the property either by a section of revolutionaries whose act was subsequently adopted by the government,
well, that's the point,
or usurping power subsequently became the government. The court won't inquire into the legality of acts done by a foreign government against its own subjects in respect of property situated in its own territory.
A third ground.
Yeah.
That's really.
I entirely accept that's a broader proposition. But if this is being said to be the foundation stone of a doctrine that permits a modern court or prohibits a modern court from recognising any act of a foreign official, then we would say it's not authority for that. Even at its highest, the act of state has been understood as just relating to expropriation of property and assets.
Well, that's the point. The last sentence is limited to foreign government, its own subjects, respect of property, situate in its own territory.
Yes, and I don't need to go.
No,
I don't need to go any higher than that.
I understand. Okay, thank you.
Now, we've handed up, and I hope it's on my lord's and my lady's desk, just to see how this line of authority has been dealt with, for example, in Dicey and Morris.
I think we're about to get
It's on
back.
its way.
Thank you very much.
Well, there are two sections in Dicey and Morris that deal with this.
So sorry, my lord.
There are two sections in Dicey and Morris that deal with this. This is concerned only with the law of property.
Yes, I'm going to take you to the other section,
Well,
at the moment,
chapter
which is already in the
5,
bundles.
Chapter 5, exclusion of law.
Exactly, my lord. That's already in the bundles, and I'm going to give you the reference for that in a moment. But this was another one that, through my omission, wasn't in the bundles. But it will help. It makes good the point that this is the case. These are cases really of, again, that can only really be sensibly viewed through private international law framework of recognition of foreign laws.
Thank you.
We've side-marked the relevant passages,
Thank you.
and I don't take you to them now. What I would like to do is
But
just
basically, it's a development of that sentence we looked at a minute ago in Lord Justice Russell's judgment, is it?
yes.
Okay.
Can I just do two other things before leaving these lines?
Is there no more general discussion of Act of State? Because this seems to be rather...
There is,
That's
my
the
lord,
other
it's in
passage you're going to
it's in the
take.
bundles, and
That you're going to take us to.
exactly.
Thank you.
Can I just take you to two authorities that give an insight into a modern understanding as to why it is we don't go behind
Yep.
foreign laws on property.
Yep.
The first is the judgment of Mr. Justice Upjohn in Halbert Wang.
Oh, yes.
That's 8 tab 65 MS 4381. This is
Thank you.
again, could I just identify the relevant passages rather than take you to them in detail,
course.
conscious of time?
Yes, yes.
4383, you can see under the held section, part of the case, which was about a German agreement in respect of debts, and then under 4, that in general every state has power to legislate in respect of movables, and a reference to Princess Olga.
Yep. Thank you.
Then the general principles are identified by his lordship at pages 3, 4, 4 to 6 of the judgment, starting with, I start with the elementary proposition at 4402, that it's part of the law of England that every civilised state must be recognised as having a power to legislate in respect of movables situated in that state and in respect of contracts governed by the law of that state, and such legislation must be recognised by other states as valid and effectual to alter title to such movables, and to sustain, modify or dissolve such contracts. And then his lordship identifies some limitations to that principle, one in respect to the enforcement of fiscal laws, 2 in respect of discriminatory laws, over the page at 4404, in respect of foreign laws aimed at confiscating the property of particular individuals. And then towards the bottom of that page at 4404, his lordship turns to both Luther and Sagal and Princess Olga and says this just a few lines up. They established a principle this court won't inquire into the legality of acts done by a foreign government in respect of property
Well, we've seen
situated.
that,
Yeah, I know we've seen that.
Yep.
Can I then just flag up, no more than that then at this stage, and one of the two other passages, 4406, right at the bottom of the page, with respect to Mr. Justice Campbell, starting there,
Yes.
down to the end of the second full paragraph, never been challenged. And then 4409,
Yeah.
the passage at the end, the last paragraph starting, in my judgment,
Yep.
to the end of the second paragraph on the following page, entering
Public policy of the country.
exactly.
This country, yeah, thank you.
Now, what this case is giving a modern take as to why we will recognise expropriation laws of a foreign country. You get a further insight into that in the speech of Lord Templeman in Williams and Humbert. That's volume 30, tab 239. That's supplemental MS 127. And if one goes to page 427E,
Wait a minute, you say volume 30?
it's volume 30, my lord, yes.
427, oh, internal 427.
No, it's tab 238. So I beg 239.
239.
And if we can go to MS page 186.
Yes, I see, thank you.
Well, it says supplementary authorities. Does it mean there are 30 volumes of supplementary authorities?
Not yet.
That's a relief, anyway.
No.
Not yet.
Yes, no.
Yep.
And this just gives you an understanding as to why it is we're unlikely. Sorry, I beg your pardon. Could you mark from D, the defendants,
Yep.
through to the following page 187E, Jerez.
Thank you. Yep.
And this again gives you a modern understanding as to why it is the courts are not going to go behind, on grounds of public policy, foreign expropriation laws, because although we might not like them, there's nothing wrong in international law per se
Yep.
about laws that confiscate.
But directed to individuals, that's an exception.
If it's directed to an individual, that's accepted. But,
Okay.
and again, these are all cases limited to property.
Yeah, in the jurisdiction of the country concerned. Yep.
Yeah, but also property not any wider. That's a
Quite.
point made by this court
Quite.
in Lucasfilm.
You understand?
And can I just give you the reference
Yeah.
to that? So that's Lucasfilms, that's Authorities 3, tab 27, MS 2435,
Okay.
and it's in the,
Sorry, could you give me that number again?
of course, it's 2435
Yep.
in the judgment of Lord Walker and Lord Collins,
Yep.
and it's paragraph 86.
Thank you. So that's page
it's worth- it's worth-
2464. Yep.
It's 2464. And
Thank you.
so the Foreign Act of State doctrine has not been applied to any acts other than foreign legislation or governmental acts of officials such as requisition.
Yep. And they cut it down if you as well,
Yes.
as is clear from the last sentence. Yes, I see. Thank you.
But, my lords, although these cases, all these cases obviously predate the introduction of Part 3 of the Private International Law Miscellaneous Provisions Act of 1995, if I can just call it PILA, they would all fall to be decided today under PILA. That's an act, of course, the court will be very well aware of. I don't think, unless it would be helpful to go into it, but just for your note, it's volume 2, tab 14, MS 1875.
Thank you.
See in particular section 11,
Yeah.
that provides it's the law in which the damage is sustained that will govern the substantive dispute in a tort action.
Yes.
And see section 14, which allows the English court to disapply foreign law if it deems that, the application of that foreign law will be contrary to public policy.
Volume 2, the 1995 Act.
Yes, I see.
Sorry, would it,
Section 14.
Perhaps we ought to look at it briefly.
yeah,
Section 11's on 1881 and Section 14's on 1882 to 3. Yep.
exactly. So you see the general rule at section 11,
Yes.
you see it's a rebuttable presumption. You can see that you can see it can be disapplied under Section 12 if, in fact, the circumstances of the case make it more appropriate to apply another law. And importantly, under Section 14.3, 1882, you can see that the foreign law can be disapplied if it would be contrary to public policy.
Did this Act result from a report of the Law Commission?
Yes, it did, and I'm afraid we don't have that in the bundle. I think it was Lord Justice
Get
Brooke.
hold of it.
And Mr. Brown Davenport, QC.
Yes, yes.
Well, I'm just wondering...
Ladies and gentlemen, today is Armistice Day, and it is approaching 11 o'clock. We ask all those in the building at this time to stop what they are doing and stand in a moment of remembrance for those who gave their lives in 2 world wars and subsequent conflicts. I will announce when the 2 minutes are over. It is now 11 o'clock. It is 2 minutes past 11. Thank you for your mark of respect.
My lady had a question. She remembers what it was.
Well, I was simply asking about this being the product of a Law Commission report and whether the Law Commission report had anything of interest to say on the general topic which we're discussing.
And you'll let us know the answer.
And I'll let you know the answer. What I can say is that the principles that you see in Part 3 are now reflected in respect of non-governmental acts in the law of the European Union. So they've been incorporated into new regulations dealing with non-contractual disputes, which are known as Rome II regulations, which contain the same presumption and also contain the same public policy exception. Can I just give you the reference to that,
yes,
if I may?
Of course.
You'll find that in volume 17, tab 122, and the public policy exception is regulation, I beg your pardon, Article 26.
Thank you. Page 7505, yeah. Okay,
Yes.
thank you.
Thank you.
And of course, this recognition of legislative sovereignty of the foreign state is mirrored in our conflicts law by respect for what could be called the adjudicative sovereignty, whereby we give effect to foreign judgments. again, subject to what can be described as public policy exceptions. So it all fits into a piece. What are the
differences, if any, between these provisions and the position, if you like, at common law before?
Well, my Lord Little, what section 14 essentially enshrines the type of exception that the court was dealing with in Oppenheim, and indeed in Q8 Airways. And I'm going to come to Q8 Airways in a minute, just to dispel any sense that that is an authority for the wider Act of State doctrine.
Yep.
So, I mean, one interesting question that arises on this appeal.
Your answer is there's no difference, is it?
No difference, no. It didn't change the test. There existed already in common law a power of the court to disapply foreign law if it thought it was contrary to public policy. That is now essentially enshrined in section 14(3) of the Act. Now, an interesting question arises as to, on this appeal, but not at all critical to the respondent's case, as to whether the description of these classes of cases as confiscation cases actually adds anything over and above a normal conflicts of law analysis. In our view, they don't. And it's actually unhelpful to apply a label such as a doctrine to these classes of cases when they can properly be explained within the private international law framework. Now, as I said, that's in no way essential to the respondent's case, because all I need to do is show that this is not authority for the extravagant notions contended for by the appellant. This compels you to recognise everything a foreign government does. But could I just give you, for your references, some thinking on this issue? I won't take you to it now, but Dame Hazel Fox, Authorities 23, tab 182, MS 9199,
Yep.
pages 60 to 62.
Which tab? Sorry about that.
182, my lord.
Thank you so much. Yep.
Dicey and Morris, and this is the section I think my Lord Sumption alluded to before, you will find in the same volume, A23 at tab 189.
Sorry, what is your actual citation from Fox?
Oh, I'm sorry, can I...
You didn't...
It's the law of state immunity, I'm so sorry.
No, but what you haven't given us is the reference that you want us to look at.
Oh, I'm sorry, it was pages 60 to 62. Would it help, my lady, if I just identify precisely those passages?
No, it would help if you identified the MS numbers of the pages.
9226 to 9228.
Well, I'm afraid I'm going to fall into the same error with Dicey and Morris. I can give you the start.
The problem is that 60 to 62 does not appear. Oh,
I'm so sorry.
Yes, I can see it now.
Yeah.
Dicey and Morris, Authorities 23, tab 189, starting at MS 9424. And if you could see in particular, please, pages... 9424, my lord.
424, thank you.
And if you could see in particular from 9425,
Yeah.
under the heading Act of State, all the way through to the beginning of 9430.
Right.
This is for the particular point, and no doubt my lords and my lady will want to see the whole of that passage, the whole of that section. And finally...
And in a nutshell, you rely on this for what proposition? Or are you going to tell
This
us?
is all a conflicts of laws point. And
Right.
that you don't really... It's not particularly helpful to start talking about Act of State doctrine in this context.
You say
because it's all caught up now. It should just be simplified.
Okay.
As I say, it's not at all essential to our case.
I mean, do you accept
Respondent's
all the
case.
principles set out in Dicey here?
Well, that's a dangerous thing to accede to.
Well, you've just asked us to look about
Partic-
5 pages. I wonder if there are any who disavowed.
Well, Can I?
You adopt the general thrust of what's in there.
So, yeah, we just need to see this through the prism of
Insofar as
conflict.
they're of assistance.
It's entirely insofar as resistance. They're entirely right, and obviously, insofar as they're not, they're.
Well, do you
Well,
accept
but-
the... Sorry.
Sorry, just looking at 5046, which states the broad principle that the appellants have been urging upon us ever since Monday, contrasting with 5047,
5047.
paragraph 5047.
Paragraphs, right.
This broad principle is sometimes used as an alternative ground for a result which can also be reached by the application of the ordinary rules of the conflict of laws.
Yeah.
Blah, 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 blah. That's what you like, don't you? You like that bit rather than the next bit.
Well, great care, for the reasons that I hope I've shown by going through the authority step by step, has to be taken to deriving any broad principle from the citation from Underhill and Hernandez. And indeed, when we go to look at Underhill and Hernandez, you can see it's actually not a case at all about act of state. It's entirely about state immunity.
I mean, I take it that you reject the summary of one line of authorities, which appears at the bottom of page 122. The English courts will not investigate the propriety of an act of a foreign government performed in the course of its relations with another state.
That needs to be seen very carefully in its context, because when I turn to justiciability and what justiciability means, I will contend that there are certain classes of transactions between states on an international level that are truly non-justiciable. So I take the court to this passage, this section, because it deals with the general point that you need to see this through the prism of law. There's a danger of going line by line
That's why
at
I
this
asked.
stage.
What you're relying on this for is simply to support the general proposition identified by Lady Hale in her question. Really, this is all conflict of laws.
Yes.
Okay.
The difficult, what comes back to it, depends what you mean by conflict of laws. Those who drafted the Private International Law Act clearly thought that law meant law. That would involve looking at the foreign state and asking whether this act was lawful under the law of the foreign state. Now, the principle recognised in Dicey at 5-047 is a different principle, as Dicey says, because it involves looking at the foreign act and saying we can't inquire or can't suggest that it's unlawful.
Well,
that's the problem. I mean, there has been recognised such a principle. The question is, how far does it go, and is it right?
Well, we've seen how that principle has been examined by English courts, and the highest it can possibly be put is that there is a class of executive act relating to the expropriation of property to which an English court must give effect. That's as high as it goes on the English authorities. Now, we've said that there's a better reading with a modern eye
So
of
if
those
Princess
authorities.
Paleolga, I'm sorry to interrupt, but if Princess Paleolga had complained that she was detained in her house while they took an inventory of it, that would be actionable in England, would it?
Yes. Now, if it was out with Russian law, let's say that case came before the court now,
Yes.
it would simply apply the following analysis. Step 1, applying Section 11 of PILA, what is the law that governs this dispute? So it's an injury or an insult.
Yes, well, I've got that point.
Step 2, is there a public... what does the law of Russia say? Now, if the law of Russia, whether under their constitutional provisions or a decree, authorised that detention, then the answer is under Russian law it was lawful, and subject to Section 14, the claim would fail. If there was no law, or if it was contrary to Russian law, then again the court would say, well, we're applying Russian law, and applying Russian law, this is unlawful, and therefore the claimant succeeds.
But if Princess Paleolga's right, that wouldn't apply to the Russian state taking her assets.
Because, as this court said in Lucasfilm, it would be confined, these are cases simply confined to expropriation of property. Now, as I say, this isn't essential to the respondent's case, but it is potentially an important point. Why have, on our analysis, properly seen, not least through the prism of Mr. Justice Upjohn and Lord Templeman and their explanations as to why we have these rules, actually properly seen in the modern eye, this is all about recognition of foreign law and conflicts, and it doesn't actually go beyond that. But at the risk of repetition, this is not critical to our case. Our case is simply showing you there is nothing in this line of authority that gets my learned friends anywhere in terms of this being a rule of law that precludes a court from going behind the acts of the foreign state, any act, even as in this case, when undoubtedly the acts were contrary to their own municipal law. Could I just again give you one additional authority, again just for you to consider on this, because it's from the Court of Appeal of Singapore.
I think Lucasfilm, on the face of it, is quite important, because you have Lord Collins taking part in a judgment where he says acts of state doctrine has not been applied. This is page 2464 in bundle 3, to any acts other than foreign legislation or governmental acts of officials, such as requisition.
Well, what was in question in Lucasfilm?
Star Wars.
How far did Act of State arise at all, and what's that passage doing there?
It's going behind whether or not the court can go behind the foreign patent.
Exactly.
But what I'm looking at is a very broad sentence, but it has Lord Collins in imprimatur. He talks about foreign legislation or governmental acts of officials, such as requisition.
Yes,
Which, on one view, rather supports what you're saying. That's the point I'm making.
yes,
Yeah. Okay. Thank you.
yes, and one can see that is a limiting rather than an expanding.
No, that's the point.
By reference to the cases that I've taken you through from starting at Carr and Fracas, through to Mr. Justice Upjohn and Lord Templeman. I mean, it's a narrow framework in which these cases have been decided in the principle.
Yeah.
The only other case which we need to look at, because it is a case that is actually one that again falls to be properly understood through conflict of laws, is Kuwait Airlines.
Yes.
Because it is a case that has been relied on, not least by the Court of Appeal in Belhaj, as a case about foreign act of state.
Yeah.
But it's our submission that properly understood, in the majority of their lordships, this was simply a conflict of laws case, no more, no less.
Right.
We find it at volume 6, tab 3414.
Page 3414, I hope. Yep. Yep.
And could we pick it up, if we may, in the speech of Lord Nichols at 3608? Now, this, as we know, is about whether or not to recognise the Iraqi decree expropriating the airlines. And we can see that straight away in the judgment of Lord Nichols, he comments that were the case to be decided once the act was in force, it would be the framework that governed it. And if we can just pick that up in paragraph 12, given the alleged wrongs were committed in Iraq and given also the absence of any particular connection with any other country, it's to be expected that when adjudicating upon the claims in an English court would apply the law of Iraq. As English law now stands, that would be so. The general rule is that the law to be used for determining issues relating to tort is the law of the country in which the events constituting the tort occurred, see sections 9 and 11.
Yep.
But the events compared before then, so we were in the Phillips and Eyre double actionability era. And an analysis that is then carried out is essentially a section 14 analysis. So the analysis is, would it be contrary to public policy to recognise the foreign law? And what was said on behalf of the Iraqi Airways was you can't have that public policy exception because it would mean going behind the Act of State doctrine. So that's where Act of State doctrine comes in, is essentially an argument you can't have a Section 14 type exception. And so between paragraphs 12 and 14, His Lordship sets the private international law framework. At paragraphs 15 to 16, he sets out the presumption of foreign law applying and the exceptions to that. The exceptional nature of the public policy exception is identified between paragraphs 17 and 19. We can see how Butts was relied upon at paragraph 24 on behalf of Iraqi Airways. And we can see the rejection of that between paragraphs 25 and 26. So it is an entirely classical public international law, private international law analysis. What's the foreign law? Should it be disapplied because of public policy? And rejecting the notion that the Act and Doctrine of State prevented you from applying it. Yes. Now, Lord Steyne applied a similar analysis. We can pick that up at page 3631. He rejects the first ground about extraterritoriality at 112. 113 moves to the private international law framework. At 114 deals with the crux of the public policy exception. The next step in the reasoning is that because of the annexation, it constituted a breach of international law and be contrary to public policy to recognise 369. So presumption is we're recognising it. Can it fall within the exception? And His Lordship analyses that. And if we turn over the page to MS 3633, he notes that this debate would now be seen within the context of Section 14. And we can see that just next to little f.
Oh, yes.
It doesn't follow, however, that every breach of international law will trigger the public policy exception. The present case is, however, a paradigm of the public policy exception. If the statutory enactment of the exception in Section 14.3 had been engaged, it would have been a classic case for the application of that provision. So that is, again, we say, just a classic private international law analysis, no more, no less. We can see that at paragraph 125, page 3636, Lord Hoffman agreed with Lord Nichols. And the only departure from a pure private international law analysis is found in the speech of Lord Hope. And it's, again, a speech that can be understood entirely through a private international law analysis. But His Lordship does go further in respect of the application of principles of non-justiciability. And we can see that starting at paragraph 135.
Thank you. Yep.
Through to paragraph 839.
So does nobody else consider justiciability?
No, they consider justiciability only really through the prism of through the Act of State argument in the paragraphs that I've shown you before. So Act of State was certainly live, but it was live only really to say there is no such thing as what we would now call a Section 14 equivalent, because you're prohibited from saying this law will be you prohibited from other than applying the local law by the doctrine. And the majority of their lordships, just applying a simple private international law analysis, said no. So
this is applying the public policy principles of common law.
Yes.
Yeah.
Which, as I've shown
Same
you,
as
two of the
Section 14.
two of the passages, both in Lord Nichols
and
in Lord Steyne, say if we were in the 1995 Act, this is how
It's
we're
the
doing
same
it.
thing.
It's the same thing.
So Lord Hope's slightly different. What about Lord Scott?
Lord Scott dissented.
Oh, he dissented, of
yes.
course, yes.
So what do we get out of Lord Hope?
Did he dissent on this point, actually?
I'm so sorry, my lord.
Did he actually dissent on this part of the...
My lord, we don't really get a consideration of these issues by Lord Scott. Lord Scott was more troubled by the fact that he thought that the Iraqi law was a fact.
Yes, exactly.
But it was what?
He thought it was a fact that the English court couldn't go behind.
Okay.
So, nothing more, we say, to be gleaned from Q8. I've given you two references about how one should package up all these cases. Could I just give you one more? Again, because of time, unless it would assist the court, I won't go to it, but just to give you a reference, how the Court of Appeal in Singapore has dealt with these issues.
Yes.
And you'll find that in volume 20,
Yep.
tab 156,
Thank you.
MS 8348.
And what's the passage you'd like us to look at?
There are three passages for you to consider.
Okay.
The first is you'll find a useful summary of the US doctrine,
Yep.
and you'll find that between paragraphs 42 and 45, MS 8365.
6. Yep. Thank you.
An analysis of the English doctrine between paragraphs 46 and 49, 8367. And then the application to the facts of that case, just for your note, paragraphs 50 to 68, starting at 8368.
Right.
Now, my lords, my lady, those are our submissions on narrow act estates, and we've sought to show that it is a very narrow doctrine that can take the appellants nowhere insofar as they seek to identify a principle of wide application that means you must give recognition to all foreign acts, even those, as in this case, that are contrary to their own municipal law. There is nothing in those authorities to support such a proposition. Mere invocation in those authorities of a passage in Underhill and Hernandez doesn't do it, and the cases need to be examined, and on examination they show no greater principle. What in reality the appellants are seeking to do is not to identify a rule of conflicts law, but to identify a rule of non-justiciability. And with that, can I turn to the second limb of our primary case, which is justiciability, and to make, if I may, under that heading, a number of observations to begin with. Firstly, Butts does not establish any freestanding principle of non-justiciability in the realm of foreign affairs. And that's evident upon the examination of the authorities that Lord Wilberforce relied upon, and by the nature of the case that was in front of him. Butts simply provides an example of a type of case that will be beyond the constitutional competence of a court to determine. It was key in Butts because it was about a settlement of a dispute not governed by law, certainly not municipal law, but turned on transactions between states on the international plane, governed by diplomacy and power politics, including the threat of military force. Shergill provides the correct test for whether or not the domestic law claim touching upon foreign affairs is or is not justiciable. The right of access to a court to exercise or vindicate a right should not be ousted, we say, by broad and diffuse incantation of phrases such as comity or prohibitions on sitting in judgment, which elude clear definition. They should be judged on the clear principles outlined by this court in Shergill. And just again, for your note only at this stage, see how the Court of Appeal in the recent Sardar Mohammed case adopted the Shergill analysis to consider the justiciability of acts of the executive overseas. For your note, Authorities 2, tab 17, paragraph 318 and sequence, MS 2021. Now, these claims, we submit, are plainly justiciable. They are governed by clear judicial standards, namely private law, and do not concern transactions between states operating only at the international plane, falling within the exclusive province of the executive and its prerogative. They concern acts of officials governed by domestic law in respect of decisions bearing directly upon the physical integrity and liberty of human beings. They are quintessentially matters for courts. My lords, my lady, in order to develop my points, I'm going to start with Butts, if I may, and look at the authorities that Lord Wilberforce actually relied upon to determine whether or not his lordship was trying to set out a very broad principle that assists my learned friends, or whether it was a much more narrow principle that fits within the Shergill confines. And once I've done that, I'm going to seek to make good 6 points. Can I tell you what they are now?
Yes.
And then come back to them. Firstly, that the respondents' claims fall within judicially manageable standards, namely municipal law. Secondly, the claims do not give rise to political issues of a Butts nature. Thirdly, there is no principled basis to distinguish the adjudication of these claims with many other examples in which our courts unquestionably examine the acts of foreign states. And I'm going to address directly whether or not a finding of illegality in this case would mark it out and would create another exception.
Yep.
Fourthly, the appellant can gain no assistance from a plea on evidence that adjudication of the claims might prejudice foreign relations. Fifthly, notions of comity do not render these claims non-justiciable, although I will identify where comity is relevant, not least in discretionary claims. And sixthly, and finally, that the appellant's submissions are contrary to powerful and persuasive dicta from comparative jurisdictions.
What was number one?
The claims fall to be assessed within judicially manageable standards, namely municipal law.
Yep. So we start with Butts.
Abuse.
Yep.
Our case is that Butts decides, no more no less, that some classes of cases concerning foreign states will not be capable of being determined by municipal courts for two reasons, either because they trespass upon the exclusive territory of the executive. Al-Haq would be a good example of a case such as that, or because, not least on the particular facts of Butts, they turn on disputes arising out of state-to-state transactions on the international plane, not governed by law, or at least not solely governed by law, but rather diplomacy and power, including, as in Butts, the use of force. Can we start with Butts? But could I just start by taking the court to the Court of Appeal in Butts and the speech of Lord Denning, simply to identify, as much as anything else, it's the most vivid description of the facts in Butts, which are, of course, important when we're trying to work out what the basis for non-justiciability is. And we will find that in volume 30, tab 241, the speech of Lord Denning starts at supplemental MS 249. And the facts are vividly set out between 569D to 571C. And they include the United Kingdom in order to make its point to the ruler of UAQ, flying a jet and helicopters over the palace, and the political representative turning up at the palace and saying he wasn't leaving until Occidental stopped drilling. So you get a real flavour of what's occurring from this judgment. Also see, just for your note, the rejection of a broad principle of act of state by his lordship. You can see, if one turns over to 252, just above letter D, that the court were taken to many books and many authorities about act of state. And we can see, for example, the Duke of Brunswick, and then below that, Underhill and Hernandez. And his lordship said at B, they've been repeated many times, these words, but the courts of England have never extended the doctrine of act of state so widely. And then his lordship distinguishes between three types of doctrine. The first above C, sovereign immunity. Second above E is the doctrine by which English courts will recognise the validity of foreign legislation and decrees. And then thirdly is the act of state itself. Now there, his lordship is talking about Crown Act of State. Now, of course, in the House of Lords, it's a broader principle of non-justiciability that's in issue. And it's worth just reminding ourselves, if the court were to turn up Buttes again, and to look at page 1790 in this. And if we just see at 1790, right at the top, his lordship is saying it's a principle that's not one of discretion, but is inherent in the very nature of the judicial process. And that is, we say, an important insight. But when we come then later to determine what is justiciable and what is not justiciable, because, I mean, in a broad sense, if something is not contrary, say, not required by other courts in other jurisdictions, it's hard to see how it could be said to be a rule that's inherent in the judicial process. But that's an important guide to what we then turn to with the cases, and it is entirely consistent with a Shergill-type analysis. Because when one looks at Shergill and asks ourselves what falls within the constitutional competence of the court, this chimes with it. Can I turn to the cases? And again, can I do so quickly? But there are some important points to make about them. And much turns on Buttes, and much turns upon how wide the proposition is, and we glean that from the cases.
Yeah.
Can I start with Blad?
Yes.
Which is the first case that
Yes.
Lord Wilberforce dealt with. Now, I don't know if my lords still have the Privy Council copy. We handed up, I think, on Monday, a free copy. If not, if it's gone missing, we have some extra.
Yes. This is 3 Swan 605.
Yes, there were two decisions of Blad, both reported by Lord Nottingham.
Yeah.
Both appeared to be either reported or heard on the same day.
This is on one page, photocopied on two sides.
It is.
Yep, very well.
Is there another copy?
Yes,
Is there a second copy?
They're coming up.
Where is Blad in the... Where's the other version of Blad?
Blad in the bundles is in Volume 1, Tab 12, MS 1837.
2 old cases of 11 and 12, yeah.
Thank you very much.
When the matter was before the Privy Council, Mr. Blad, a Dane, was held in custody, and it was an issue before the Privy Council as to whether or not he should be released. The second case deals with the civil action, and the whole report can be easily read, but one can just pick it up. at the bottom, I stood up and said it wasn't a question of state but of private injury, that the king could not now demand justice of the King of Denmark, because had the wrongdoer in his own power, and ergo, if he let him escape, there could be no reprisal, that it was an injury to the subject to stay his proceedings at law, and no injury to the Dane to let the suit go on. And then this is the key bit. Whatever was law in Denmark would be law in England in this case, and would be allowed as a very good justification in the action. So if the Dane had lawful authority, because I know Mr. Reedy said this was a case about extraterritoriality. It's absolutely not. The Dane seized the goods in Danish territorial waters.
Well, wait, is that right? 1837 says it was upon the high sea.
Ah.
In the middle of the page.
Well,
and that's why there was discussion about the
sorry,
Admiralty jurisdiction.
my lord's right. And I need to come back on that. But can I make the key point anyway, which is, so far as the Privy Council are concerned, if Mr. Blad had a lawful authority to seize the goods under Danish law, that was going to be the law that the English courts would recognise, and that's what the Privy Council is saying in that passage. And that is entirely consistent when we come to the report in Chancery with how the court approached it. Could we, if I can help my lord any more on the Privy Council, could we then turn to Blad in Chancery, which is, as I said, 1837 of Volume 1. Now, here, this isn't about the release of the Dane, it's about the Dane's application to stay a claim in trespass and trover in respect of the goods that he seized. And the plaintiff's application was premised upon what was said to be his right to trade, provided for in letters patent by the King of Denmark. And the defendant sought to resist the stay, relying on the rights to free trade under a peace treaty. And the court, as we'll see, had some concerns about interpreting a peace treaty. And that's again going to be the type of issue we'll see played out in other authorities, but did so. But what was held to be decisive in this case was that it would not go behind the letters patent of the King of Denmark. And could we pick it up at 1837? Towards the last quarter of the page. It's very true this cause was dismissed from the Council Board, being not looked on there as a case of state, because for aught appeared to them it might be a private injury and unwarrantable, and so fit to be left to a legal discussion. But now the very matter of defence offered by the defendant has made it directly a case of state. For they insist on the articles of peace to justify their commerce, which is of vast consequence to the public, for every misinterpretation of an article may be an unhappy occasion of war. And if it had been known at the board this would have been the main part of their case, doubtless the council would not have suffered it to depend on Westminster Hall. But in truth, this pretence of articles of peace must needs fail the defendant. The articles of free trade are reciprocal and are understood on both sides with exception to the laws and customs of each kingdom. Put the case then that a Danish ship should trade to Barbados or any other part of His Majesty's foreign plantations and were thereupon taken and seized or should break in upon the privileges granted by His Majesty to the East India Company and were then arrested, doubtless there were no breach of the treaty on our part. And if any of His Majesty's subjects who seized the ship at Barbados or judges should then be molested or prosecuted in Denmark in a private action for what they did in obedience to the laws of their king and country, it would look like such a breach on their part as might well occasion further rupture. Ergo, to come to the present case, certainly no case was ever better proved, for the plaintiff hath proved letters patent from the King of Denmark for the sole trade of Iceland. A seizure by virtue of that patent, I should pause there, at this stage Iceland is part of the territory of Denmark. A seizure by that patent, a sentence upon that seizure, a confirmation of that sentence by the Chancellor of Denmark, an execution of that sentence after confirmation, and payment of 2/3 to the King of Denmark of the execution. Now, after all this, to send it to a trial at law, whether either the court must pretend to judge the validity of the King's letters patent in Denmark, or the exposition and meaning of articles of peace, or that a common jury should try the English have a right to trade in Denmark, is monstrous and absurd. So, my Lord, reading that passage, we say that this is a case, really, that supports two modern propositions. One, one of justiciability, one of private international law. The private international law one is obvious, we've seen it. You're going to give effect to the sovereign law of Denmark. The justiciability issue is the concerns that the Chancery Court had as to dealing with a peace treaty. A treaty between two nations on the international plane, but nevertheless did interpret the peace treaty, noting that properly interpreted, it simply gave reciprocal rights to recognise each other's laws.
Well, that's not what is being said in the passage towards the end of the penultimate paragraph.
No, that's absolutely right, my lord, but if one goes back the page, it's undoubtedly the case that the court is looking at the Articles of Peace. Because if you go 5 lines up from the bottom of 1837, as I said in the passage I just read, the pretence of Articles of Peace must needs fail the defendant, for the Articles of Free Trade are reciprocal and understood on both sides.
With the exception, yeah.
To be absolutely clear, it's no part of my case that peace treaties are, per se, justiciable. But what I'm seeking to do here is to demonstrate that there is nothing in Blad that supports any wide, free-ranging notions of non-justiciability simply because you are sitting in judgment of a foreign state.
Well, it doesn't it? I mean, on what? It's not a conflicts of laws point, because on the high seas there is no domestic law. This was an arrest on the high seas, it appears, an action in relation to it, and the answer seems to be you can't ask us to construe the Articles of Peace to argue that you were free of arrest. Danish law entitled the king to arrest on the high seas, and that's an act which we can't inquire into. Isn't that the sort of reasoning?
Well, my lord,
You
with respect, my lord's absolutely right to say that the seizure was one done on the high sea. Sorry, the trespass.
Yes.
But
It was all blessed by Danish.
But if one
law.
looks, if one, yeah, but the torts complained of are ones that are done in Iceland, and you can see that simply by the head note: perpetual injunction to restrain proceedings against a Dane for the seizure of property of English subjects in Iceland, which is for the purposes of recognition of the foreign law, the Danish law.
But the ratio is surely that this was a sovereign act of the state of Denmark outside its national territory.
No, my lord. The ratio is, in respect of the cause of action, which was thought to be justified by Danish law, the English court won't go behind it.
But how could Danish law govern the course of action if it was on the
Well,
high seas?
the goods might have been taken on the high seas, but they're converted in Iceland.
Is that right? It doesn't. It's difficult. Doesn't English subjects in Iceland? Does in Iceland qualify English subjects? I.e., they were living. He was living there. Is that?
I'm so sorry, my lord.
Oh, well, does English subjects in Iceland not refer to where the English subjects were resident? That's my question.
Trading, line 5.
I mean, he was importing.
Oh, I see.
He was
I see.
importing
I'm so
them
sorry. Yeah,
into
I see.
Iceland to trade with them there, but they were seized from him on the high seas. That was the trespass.
They were seized.
Well, I mean,
I think that's how I read it.
I mean, to some degree, this discussion
Shows how difficult.
shows the need for caution, if nothing else.
The facts seem pretty straightforward. It was because they'd traded in Iceland. That was the reason given by the state of Denmark for seizing their property outside the national territory of Denmark. That's as plain as can be.
Well, my lord would say it's not, actually, that when you read it, it's about giving recognition to the law.
Yes, but we don't give recognition normally to the extraterritorial scope of laws, and so this seems to be authoritative for some wider proposition, namely, which I think one can understand, can't one? But you would say it's a very different case from the present, but it is seizure by force, pursuant to domestic laws, but on the high seas. Would we today claim to adjudicate in respect of that sort of matter? It might be said to be quite similar to Butte's gas.
Might be, particularly if it turns upon a peace treaty on force in foreign waters, then it could be properly understood in terms of Butte's gas non-justiciability. I mean, I think one can say this can be read in a number of ways, but it cannot stand as a core of an analysis for the type of broad rule of non-justiciability that my learned friend contends for, nor when we read through Butte's, is it being relied upon?
Well, let's move on to another case.
Well, let's move to the Duke of Brunswick.
I mean, Lord Wilberforce obviously thought that it had the significance which I think Lord Sumption and I were suggesting.
Well, my lord, I'm not sure. Can I work my way through the authorities before?
Let's go on to the Duke of Brunswick.
Just test what
this later, but there are some analogies with the issues in the Playa Lager, where the doctrine was held not to apply because of exceptions relating to extraterritorial acts, but there seemed to be absolutely no doubt that the doctrine itself, subject to the exceptions, would apply in this sort of situation.
Can I come to Playa Lager?
Yeah, let's move on to Duke of Brunswick, page 1827 of the same bundle.
Well, I'm going to start actually with the Court of Appeal in the Duke of Brunswick, if I may, which you'll find in volume 30, tab 242, supplemental MS 263. And if we could start, please, to seeing how the case is put in the judgment of the Master of the Rolls at 272.
Yeah.
Where have we gone to?
If you just mark third paragraph saying the bill.
30,
242.
I'm sorry.
242, page 272.
Brunswick, yes.
Thank you.
Yep.
Court of Appeal.
You could just mark for an explanation of how the case is put next to the paragraph, third paragraph starting the bill praise.
Page?
Page 733.
Sorry, that's the 272, yeah, okay. The bill.
I'm so sorry, 272.
The bill praise, yeah, thank you, about two-thirds of
So
the way down.
you're going to get the facts from there. On the next page, 273, you're going to see the bill that was sought to be impeached in the action, which was the bill dispossessing and appointing a guardian. And the entire issue decided by the court is one of sovereign immunity. It's whether the King of Hanover was being sued in his capacity as a foreign sovereign, in which case he would have immunity, or whether he committed those acts as a British subject, in which case he might not have immunity.
Or whether they're private acts.
Precisely. It's a little it kind of mirrors Pinochet further down the line between private and official acts. And we can see the analysis. And if I could just ask you to read page 284, right at the bottom. Admitting it to be the general rule that as sovereign princes are not liable to be sued, they consider themselves interested to maintain. If I could then just ask you to mark the rest of the judgment, because it's absolutely apparent that the only issue that is being considered by the Master of the Rolls is that of state immunity.
Yeah.
You're being asked to double mark a bit by my learned friend at 285, the penultimate paragraph, talking about acts being done abroad.
The object of the suit.
The object of the suit. Is
Very
it
well.
a bit,
Thank you.
Yeah, well, in fact, absolutely. And we rely on that because that is reaffirming that what the court is dealing with here is state immunity. Because for the purposes of state immunity, it doesn't matter where a foreign sovereign committed his or her acts.
So which is the passage you say absolutely shows this?
I think Mr. Eady wants you to give particular emphasis to the penultimate paragraph on page 285, starting the object of the suit, and I think to give stress to the fact that the acts were said to be conducted abroad.
Yep.
Although, actually, where the court here is referring to abroad, it means outside of England. But nevertheless, I think Mr. Eadie's point is that it means outside of Brunswick. But even if that point were to be correct,
Outside of
even if that
outside
point
of Hanover. Outside of Hanover.
even if that point were to be correct, it simply affirms that this is about state immunity. Because, of course, for the purposes of state immunity, it's irrelevant where the King of Hanover committed his acts, whether they're in Paris or in Berlin.
Understood.
Now, it's exactly the same position before the the court, before the Privy Council, I beg your pardon, the House of Lords, which we find at Volume 1, Tab 11, starting at 1827. And if we can pick that up in the speech of the Lord Chancellor at 1832.
Yep.
Second paragraph, the whole question seems to me to turn upon this, that is to say, for the purposes of this decision, it's not been otherwise contended at the bar, that a foreign sovereign coming into this country cannot be made responsible, and then, if there is to be some double underlining, can it be on this word, here, for an act done in his sovereign character in his own country, whether it be an act right or wrong, whether according to the constitution of that country or not. The courts of this country cannot sit in judgment upon an act of a sovereign effected by virtue of his sovereign authority abroad, an act not done as a British subject, but supposed to be done in the exercise of authority vested him as a sovereign. It's sovereign immunity, no more, no less. Of course, in all these speeches of their lordships, there's a discussion as to whether or not it makes a difference whether it's personal capacity or private capacity, but it's about, the decision is about state immunity. And we see that, again, if we could just turn to Lord Lyndhurst at 1834, who is entirely of the same opinion. None of the acts upon the face of the bill was done in this country, nor is it appears...
1834?
1834.
Whereabouts?
Right at the bottom.
Right at the bottom. I'm so sorry. You see Lord Lyndhurst.
Yes, I'm with you. Yeah.
Yes.
Already looked at it.
None of the acts stated upon the face of this bill was done in this country, nor, as it appears to me, by the defendant in his character of a subject of this country. They were all done abroad. And that's where we get what abroad means. And admitting that the circumstances may exist in which a foreign sovereign may be sued in this country for acts done abroad, about which I say nothing, because it's not necessary to decide a question, there are no such facts stated upon this bill to justify entertaining a suit of this description. Over the page, Lord Brown agrees with both his learned friends. The moment you come to look at the facts disclosed, which the demurrer admits for the argument's sake, denies the equitable jurisdiction, the moment you see those facts, it's clear in every way this is the case of the interference of the Court of Equity. It would have been necessary, where two foreign princes come to courts of this country, respecting a matter transacted abroad, to have disclosed such a case as would have been shown that it was upon a private matter they were acting as a private individual, so as to give the courts this country jurisdiction. So he then embarks upon a discussion which he doesn't reach a clear view on, as to whether or not it was such a case. And Lord Campbell, slightly wider discussion in which he again postulates whether or not the court would have had jurisdiction if it had been the English sovereign sued rather than the foreign sovereign sued, again reaches clear conclusions. And I mean that's exemplified not least by the citations I think my Lord Hughes identified, or Mr. Eadie took us to it, at the very end of the judgment at 1836. Yeah. Lord Chancellor would not grant an injunction against the French Republic marching an army across the Rhine or the Alps. So this is a case about state immunity. Lord Wilberforce then moves from England to America and looks firstly at the case of Underhill. We find Underhill in volume 22 at tab 180 at MS 9162.
What page?
It starts at 9162, my lord.
Thank you so much. Yep.
And it's a short judgment from the Chief Justice, which starts at 9164. And it begins with the famous passage.
Yeah.
Sorry, what volume are you in?
I'm so sorry, my lord. It's in volume
22.
22. You'll find it at tab 180.
Yep.
Thank you.
And if you turn to page 9164,
You get the famous first paragraph.
you get the famous first paragraph.
Yep. Yes?
Having set out that paragraph, the case then turns to one about sovereign immunity, because it's a question as to whether or not the defendant could be sued in the United States court. And we can... this was a case brought in the United States courts in respect of acts recognised as sovereign committed outside of the United States. And that is all the case is about. And the only basis on which this has been identified as a source for a broad notion of foreign act of state doctrine is that opening paragraph.
Right.
Sorry, what do you say it's authority for?
It's a state immunity case.
So the
Let's-
whole of subsequent American jurisprudence, which has treated this as the classic statement of the act of state doctrine, has proceeded under a fundamental misunderstanding. Is that right?
Well, no, because since 1982, my lord, they've rejected the notion of an act of state doctrine based upon these broad notions.
Well, they-
And it's now confined, since Sabatino in 1982, to their understanding of their own internal constitutional makeup.
They've changed the rationalisation of it, but it's always been regarded, whatever its rationale, as a case about act of state. And on the face of it, that's what it was. It wasn't an action brought against the state, it was against General Hernandez, who was not the state or the head of state, but a
Yes,
general.
but insofar my lord is suggesting, which sounds my lord is not suggesting, but my lord is suggesting that this opening paragraph in this case is now is a jurisprudential basis for the foreign act of state doctrine in the United States.
I'm not
The answer is no.
It has changed.
Whether or not this is cited, and it can still, I mean, nothing in here is per se objectionable, obviously. And my learned friend yesterday set out how we give effect to this principle, not least through state immunity, and many of my submissions on private international law give effect to it. What this statement can't be done is to transpose it into a justification for a common law rule of the nature identified by my learned friend.
Underhill Hernandez has very frequently been treated as a correct statement of principle in the context of act of state cases in this country.
Yes.
There's a great list of the cases in Dyson Morris.
Yes, and my lord, it is certainly our case that insofar as courts have sought to identify the type of hybrid notion of act of state non-justiciability that the Court of Appeal did in Belhaj, they were wrong to do so. That what you cannot do is extract from this some sort of freestanding rule of non-justiciability in common law that ousts your right to your remedy. And that is reinforced, that's why I take the court to this, it's reinforced because actually it's not unreasonable to say have a little care here. It's a statement of general principle in paragraph 1, then applied to facts about state immunity.
Well, state immunity wasn't pleaded, obviously. Otherwise, the case wouldn't have been tried.
Well,
I mean, it was tried by a judge. It came up on appeal, and Hernandez was represented. So
Well,
it was a case on substantive law, as I say.
well, my lord, what we don't have for the court are the proceedings below. So we don't know whether this was a point that was raised, that was thought about. Obviously, the notions of state immunity were well advanced at this time, but they weren't quite as advanced as they are today. So we don't know if it was a point that was thought of. But what this is a decision about is that you cannot bring a foreign sovereign before your courts in respect of their sovereign acts overseas. That's what this case is about.
Well, at best he was an agent of the foreign state. You say it's like Jones these days, do you?
Jones, the principles in Jones of state immunity are reflected in Underhill. He was an official. And so in Jones' analysis, the state's liability in international law is engaged, irrespective of what he's alleged to have done.
Well, the Chief Justice approves the ruling of the lower court that the acts of the defendant were the acts of the government of Venezuela.
Yes, yes. So that's your starting point for state immunity. And therefore, because of that, United States courts can't hear the case.
Yep.
Next, in Buttes, His Lordship considers Cook and Sprigg, which we find in Volume 9, tab 74, starting at MS 4623. This was a case brought to seek to enforce property rights said to have been granted to the appellants by Sigau, the paramount chief of Pondoland. The Premier of the Cape Colony denied the claim on the basis the British government was the sole paramount authority in Pondoland. The key argument of the state is identified at page 4627. You'll see it 7 lines down, starting, a subject cannot sue the government, which is annexed territory by an act of state, to enforce claims.
Yeah.
This is, of course, a Crown Act of State case, but it's relied upon by Lord Buttes. The Privy Council refused the appeal on the principal ground that the case turned upon transactions of independent sovereigns, namely Great Britain and the Sigau, and as such was not governed by municipal laws, but by laws which municipal courts administer. And we can see that at the passage starting on 4628.
Yep.
Their lordships, right at the bottom, their lordships do not differ, through to 4629, just before the last paragraph, ending in diplomatic pressure. And in fact, it's worth, in your lordship's note, going all the way through, actually, to 4630. Now, this is another clue to what Lord Wilberforce considered to fall within the non-justiciable category of cases inherent in the very judicial process. Asking a court here to determine rights brokered between two sovereigns on the international plane. It's an insight into Lord Wilberforce in Buttes, and it is also the type of case, albeit a Crown Act of State, that still falls well within the Shergill understanding of constitutional competence of the courts. State to state on the international plane, not governed by municipal law. Now that's made very clear, that distinction between cases governed on cases concerning transactions on the international plane and municipal law, in the case that both the House of Lords considered in Cook and Sprigg and Lord Wilberforce went on, which is the case of Comanche Boy Saba. And can I turn that up next, which is in the same volume 9, tab 76, MS 4655.
Yep.
Now, this concerned a seizure by the East India Company, acting as a sovereign power in trust for Great Britain, of the property of the Rajah of Tanjore, who died without a male heir. The issue is identified.
Sorry, what page are we on again?
4655.
46, but if we can turn to 4674.
Right. So, yes, this is, yes. This is the judgment quoted in the earlier case. Yep, couldn't be.
I'm so sorry, my lord.
Don't worry.
It is quoted in the, but I'm going to make there's an important distinction that's drawn by the court here that I want to give some emphasis to, because it's relevant to Butts and it's relevant to Shergill.
Yeah.
So you can see the issues if we start at the second paragraph of the speech of Lord Kingsdown. So starting in the very able argument. Now, just if I can ask you to mark all the way through, and I'm going to come back to a passage, all the way through to the following page, 4675, to the end of the penultimate paragraph, has no foundation. The issue before the court was this a transaction that the municipal court could adjudicate upon?
Yeah.
Or was it at a level beyond the competence of municipal courts? And we can see that question put. 4675.
Yep.
Under 7.6, we can see secondly, there was a point about the sovereign powers of the East
The
End
seizure
Company.
in this case. Yep.
Did it not take place by exercise of sovereign power against another independent power, but was mere succession by asserted legal title? Now, His Lordship dealt with that at the penultimate paragraph. The next question is, my Lord, have that?
Yes.
What is the real character of the act done in this case? Was it a seizure by arbitrary power on behalf of the Crown of Great Britain of the dominions and the property of a neighbouring state, an act not affecting to justify itself on grounds of municipal law? Or was it, in whole or in part, a possession taken by the Crown under colour of legal title of the property of the late Rajah of Tanjore, in trust for those who by law might be entitled to it on the death of the last possessor? If it were the latter, the defence set up, of course, has no foundation. So if it was governed by municipal law,
Understand.
you try it. Lord Wilberforce then turned back to America, to the Supreme Court case of Ochen, which we find at volume 22, tab 179, MS 9154.
Right.
This is a case, I should say.
I'm so sorry, Mr. Hemel, where?
We're in volume 22,
22.
tab 179,
17.
Thank you.
starting at MS 9154.
That's very well.
This is a case that goes a little wider on principles. It concerns a case about the seizure of the consignment of hides by the de facto government of Mexico. At page 9159, the courts applying Underhill recognise that you've got to give that the revolutionary government needs to be recognised as sovereign, and then we can pick it up at 9159, last paragraph.
Yes.
Results of the interpretation by the court of the principles of international law that when a government originates in revolution or revolt is recognised by the political department, such recognition is retroactive in effect and validates all the actions and conduct of the government so recognised, see Williams. To these principles we add the citation from Underhill. Applying these principles of law, we duly commission military commander what must be accepted as the legitimate government of Mexico in the progress of a revolution, seizing and selling as military contribution the property of controversy at the time owed in the possession of the citizen of Mexico, the assigner of the plaintiff in error. This was an action in Mexico of the legitimate Mexican government dealing with a Mexican citizen, and as we have seen, the soundest reasons and repeated decisions of this court is not subject to re-examination and modification by the courts of this country. So to some degree that could be said to fall in the kind of Princess Olga type of category as we would have seen it in our conflict of laws approach. But as is shown from the next case that Lord Wilberforce went to in Buttes, Sabatino, there was a radical departure in approach from the American courts. And we can see Sabatino at in the same volume, 22, at tab 178, starting at MS 9079. The facts of this case were similar to many expropriation cases. They concerned the expropriation of a US sugar broker's Cuban rights. And the opinion of the court is delivered by Mr. Justice Harlan. That starts at 9018, and he begins his consideration of foreign act of state at, 9102. So he starts off the discussions about the foundations on which the Act of State doctrines rest, and the particular question before the court whether it was federal or state law which governed it. We don't believe this is a doctrine compelled either by the inherent nature of sovereign authority.
So which page are you reading from?
I'm reading from 9102, my lord.
Yep.
We don't believe that this doctrine is compelled either by the inherent nature of sovereign authority, as some of the earlier decisions seem to imply, see Underhill, amongst others, or by some principle of international law. If a transaction takes place in one jurisdiction and the forum is in another, the forum does not, by dismissing an action or by applying its own law, purport to divest the first jurisdiction of its territorial sovereignty. It merely declines to adjudicate or make applicable its own laws to a party or property before it. The refusal of one country to enforce the penal laws of another is a typical example of an instance when a court will not entertain a cause of action arising in another jurisdiction. While historic notions of sovereign authority do bear upon the wisdom of employing the Act of State doctrine, they do not dictate its existence. That international law does not require application of the doctrine is evidenced by the practice of nations. Most of the countries rendering decisions on the subject fail to follow the rule rigidly. No international arbitral or judicial decision discovered suggests that international law prescribes recognition of foreign acts of foreign governments, see Oppenheim, and apparently no claim has ever been raised before an international tribunal that failure to apply the Act of State doctrine constitutes a breach of an international obligation. If international law does not prescribe the use of the doctrine, neither does it forbid its application of the rules, even if it is claimed that the Act of State in question violated international law. The traditional view of international law is that it establishes substantive principles for determining whether one country has wronged another. Because of this peculiar nation-to-nation character, the usual method for an individual to seek relief is to exhaust local remedies and then repair to the executive authority of his own state to persuade them to champion his claim in diplomacy. Although it is, of course, true the United States courts apply international law as part of our own inappropriate circumstances, the public law of nations can hardly dictate to a country which is in theory wronged how to treat that wrong within its domestic borders. Despite the broad statement in Ochen that the conduct of foreign relations of our government is committed by the Constitution, it cannot be thought that every case or controversy which touches on foreign relations lies beyond the judicial cognizance. Baker and Carr, that's a political doctrine case. The text of the Constitution does not require the Act of State doctrine. It does not irrevocably remove from the judiciary the capacity to review the validity of foreign acts of state. The Act of State doctrine does, however, have constitutional underpinnings. It arises out of the basic relationship between branches of government in a system of separation of powers. It concerns the competency of dissimilar institutions to make and implement particular kinds of decisions in the area of international relations. The doctrine as formulated in past decisions expresses the strong sense of the judicial branch that its engagement in the task of passing on the validity of foreign acts of state may hinder rather than further this country's pursuit of goals, both for itself and for the community of nations as a whole in the international sphere. There's some comments about disagreement amongst some commentators. Could we then move, please, to 9108, which is about...
You're going to read a long chunk. It's probably better we read it to ourselves.
Yes, of course. Can you then read, please, from 9108?
Well, where? From heading 6?
Heading 6, the Act of State doctrine.
To where?
To, if you could read, please, to 9112, end of the paragraph ending latter case.
Yeah, thank you.
So it's an express move away from a doctrine based upon the incantation in Underhill, to one that is based upon the notions under the United States Constitution of separation of powers. It's not really, in our sense, a notion, in an English sense, a notion of non-justiciability. It's what's called a rule of decision. So even in a case in which an act of state may be engaged, the court can still, nevertheless, deem it appropriate to consider the case. It will look at the nature of the foreign state, whether it's still in government, for example, and the impact upon foreign relations. That's what's meant by a rule of decision. And it's applied, certainly in 1982, as we can see from page 9109, in respect of the taking of property.
I mean, it's not wholly, they haven't wholly abandoned a concept of some kind of comity between nations, because that seems to be the consideration discussed at page 430 of the report, when
Yes.
they explain the sensitivity
Yes.
of...
Well, that impact, though, that can be a directing ground as to whether this falls something within the exclusive remit of the executive in the relation of foreign affairs, or is appropriate for the court. There's a very different notion. I mean, there's obviously some similarities between notions of separation of power between here and America, but there are some real differences, and we'll see those in a moment when we look at some other cases. Certainly in 1982, the Supreme Court is only looking at expropriation of property, and it sees the doctrine confined to that. It is invoked in wider cases, not just relating to expropriation of property. We can see that when we look at Kirkpatrick in due course, but it's not been applied beyond that to the best of our knowledge.
Yep.
As a result of Sabatino, Congress passed what is known as the Hickenlooper Amendment, that provided that the court could go behind expropriation orders if it was deemed contrary to essentially public policy not to do so.
The what amendment?
The Hickenlooper. I'm going to show you a little bit of it in a moment by turning to the last case that Lord Wilberforce considered in any detail, which is the Fifth Circuit in Occidental.
Right.
we can find that in Volume 1, Tab 9, at MS 1798. This is, of course, part of the whole Buttes litigation. This was a conversion claim.
Yep.
The first instance court had ruled that the claim should be dismissed because its adjudication would call into question the acts of foreign states.
Yeah.
The appeal court dismissed on different grounds, on two different grounds. Firstly, it held that the claim required determining the sovereignty of Abu Musa, which was disputed by 3 nations, and was thus non-justiciable under the political doctrine, the political question doctrine in United States federal law and state law. And secondly, because there were no judicial manageable standards by which to adjudicate the claim. You can see the start of the report with the different grounds for dismissal at 1808. These conversion actions consolidated on appeal. The federal court has asked for a decision we consider impossible. The immediate question is whether the district court erred in granting the motion. It determined it should refrain from deciding the issue because the decision would call into question the acts of foreign states. We dismiss on the slightly different ground that the question presented is political, being both constitutionally devolving on the executive and judicially unmanageable, and therefore not a case or controversy within Article 3 of the Constitution. That's the clause giving jurisdiction to the federal court. So we can see almost by the language that we're in Shergill territory. You can see the Hinkenlooper amendment. It's the relevant parts are set out in a footnote at 1804, footnote 6.
Right.
Hinkenlooper.
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 Looper. Yeah.
The court turns firstly to consider the political question doctrine, and it starts that just at the end of the second column on 1804, and then moves to consider act of state. And if I could kindly ask the court to read from there through to the end of the first paragraph, second column on 1808, ending political action of the sovereign themselves.
I'm sorry, where is it you wanted us to?
From 1804, starting a political question clearly emerges, to 1808, second column, ending just above 13, action of the sovereigns themselves.
Yeah.
Key line in these passages is the one found at 1808, just at the end of the first paragraph.
Okay.
Were we to resolve this dispute, we would not only usurp the executive power, but also intrude the judicial power beyond its philosophical limits.
Well, that's a phrase which no member of the International Court of Justice would accept. It's curious language here. What they really mean is that this is an international law issue, which is outside our, above our pay grade.
No, my lord. They're saying this is the case that concerns transactions between states on an international plane that municipal law cannot grab hold of and determine. It's beyond the scope of our constitutional competence.
Yes, well, I agree with all that. It's the same thing. But to say that it's beyond the philosophical limits of judicial power is odd, to say the least, because it's the sort of issue which could and should be decided if only nation states would agree to the jurisdiction of the International Court of Justice by judges at that level.
I'm so sorry, my lord. I've entirely missed.
It's basically, if you read the word municipal before the word judicial, everything is harmony between you.
Right.
I entirely missed my Lord Mant's point, which is entirely my fault.
Don't worry.
My Lord's absolutely right,
Yes.
in the sense that there are lots of issues that these courts would say, this isn't governed by municipal law, this is outside our constitutional competence, but nevertheless an international court could grapple with them.
I mean, the particular problem in America seems to be that actually the executive has a considerable role also in declaring what the international law position is, and that may be why they're using the phrase political question.
Yes, and under the American Constitution, it's much more clearly... the American constitutional setup is obviously different. They have a conception, obviously they share a concept in general terms of separation of powers, but how that manifests itself is different, as we can see from the analysis of Baker and Carr.
The State Department issues letters, in effect certifying what the executive's view of international law is. I mean, the Tate letter on qualified state immunity is a famous example.
Yes, I mean, we have certification here, but in a much more limited sense.
We would never, the executive would never certify what international law was in this country.
No. It might certify what it recognises as a boundary for a given country, but my lord's absolutely right.
What the result is, what it...
Yes. But, so this decision gives us insight as to what Lord Wilberforce meant when he said that the court would be in judicial no man's land, and that there was a lack of manageable standards.
Yeah.
And we can see it's a fitting point to end upon the line of the jurisprudence, starting with Blad, which is we seek to show all those cases are about narrow application, are of narrow application.
But I just take you back. I mean, you're effectively asking us to say that Lord Wilberforce was wrong in Butte's Gas at 1790 in his analysis of Duke of Brunswick and King of Hanover. He faces up to the fact that it's somewhat obscure and there are two strands, but he does identify, bottom half of 1790 to the top of the next page, he does identify a strand which he considers addresses a different principle from sovereign state immunity.
Well, as my lord says, at 1791, his lordship acknowledges that these cases are directed to whether a sovereign can be brought into account in this country. I don't say that he is wrong if he is doing nothing more at that stage than drawing out of Duke of Brunswick the principle that there are transactions between states that are not justiciable by local courts. He is not saying, and would have been wrong if he had said, that Duke of Brunswick is authority for the type of proposition that my learned friend seeks to highlight. So, my lords, looking at the authorities relied upon by Lord Wilberforce and looking at what Lord Wilberforce said and how he applied it in his famous concluding passage at 936, we make these following observations. Firstly, that there's nothing in any of the authorities relied upon by Lord Wilberforce, nor does Bute stand for, the proposition that an English court cannot assess the legality of acts of foreign governments per se. The authorities in the analysis of Lord Wilberforce highlight that there are a certain class of transactions between states that courts are not equipped to adjudicate upon, and which it's inappropriate for them to adjudicate upon. And these are a certain class of state-to-state transactions on the international plane. They are transactions on a horizontal plane, exclusively between states. They are state-to-state transactions rather than transactions of a state on a vertical level, transactions that directly concern private individuals and their rights. They are also transactions not governed by municipal law, but either solely by international law or sometimes by international law and power politics, in respect of which courts simply have no tools to adjudicate, nor would it be appropriate for them to do so. There is nothing in Bute's Gas that seeks to suggest or support a proposition that the House of Lords was seeking to identify a freestanding rule of the non-justiciability of foreign acts of states. To the contrary, all of Bute's can be readily understood and applied to the Shergill framework. The judgment of this court in Shergill provides the correct framework for identifying with principle and with reason, in a manner that anybody can understand, why some claims are justiciable and some are not. It reflects, in the context of foreign affairs, the simplicity of Dr. Mann's pithy description of justiciability, where he said, and I'll give you the reference in a moment, to put it shortly, an issue is justiciable if it's capable of being tried according to law. Insofar as foreign relations in England are concerned, this means in substance, justiciability is lacking only where issues come within the exclusive provenance of the executive and its prerogative. You'll find that in volume 30, tab 244, MS31, supplementary MS 313.
Yeah.
And it 314, and it reflects, we say, the thinking and the clarity in Shergill. Can I now turn to the 6 points that I was going to make after the Bute's analysis? Firstly, that these claims fall within judicially manageable standards. These are claims for personal injury and loss of liberty. The facts might be extraordinary, but the legal framework is not. They are premised exclusively in private law, and the identification of the relevant private law is made under our private international law rules of the 1995 Act in precisely the same manner as if this were a road traffic accident occurring in New South Wales. The parties have yet, in fact, to plead the relevant provisions on applicable foreign law, but it is reasonable to proceed on the assumption that they provide a legal framework that prohibits torture, kidnap and rendition, and that they provide civil remedies for the victims against those responsible for their mistreatment, enforceable before courts. Insofar as any of those foreign laws did not, or even if they sanctioned such behaviour, then an English court would be invited to disapply them. Thus, it is likely that the English court will be giving effect to the legislative sovereignty of foreign states by applying their laws. Far be it from interfering with their sovereignty, the true analysis is that the English court is being asked to faithfully apply the law of the foreign states passed by their legislature to secure remedies against defendants resident here. Yeah. The claims are brought here, not least to respect important principles of sovereign immunity. The defendants, as officers of the British executive, are entitled to insist on being sued in the English courts and not abroad. At all times, the appellants were subject to municipal law. There was nothing about the nature of their activities that relieved them of obligations to act lawfully under municipal law, and there is nothing to suggest that their acts and omissions should not be judged by municipal law. Indeed, under the provisions of Section 31 of the Criminal Justice Act of 1948, all British subjects employed by Her Majesty's government are subject to UK criminal law in respect of acts committed overseas. And in these circumstances, both courts below were entirely right to conclude that the claims fall to be determined in accordance with clear judicial manageable standards. The international law framework, although not bearing directly at all upon civil liability, cannot undermine the case. In contrast to Buttes, when at the time it was decided the law of the sea was uncertain, UNCLOS had yet to be brought into effect, there is overwhelming consensus as to the prohibition on torture and arbitrary test. So this is a case in which there are manageable standards that fall within the Shergill framework. If a case is capable of being determined by municipal law, then that is because it arises out of an activity governed by municipal law and is therefore highly likely to fall within the constitutional competence of the courts. If I can be forgiven for stating the obvious, laws do not exist in a vacuum. If they exist, there must be a court capable of adjudicating upon them. The class of cases that fall more obviously into the exclusive realm of the executive, such as the entering of peace treaties, appointing and receiving diplomats, are those falling within the prerogative and consequently less likely to be capable of adjudication by reference to domestic law. The less an activity of government is governed by municipal law, the more political, within the Shergill meaning, its activity is likely to be. That takes me to my second point, about political acts within the meaning of Shergill. Neither of these appeals concerns state-to-state transactions purely on the international plane, nor do they concern, even incidentally, the rights or liabilities of one state vis-à-vis another. Rather, they concern the actions of individuals subject to law in relation to other individuals, and they concern the fundamental rights of those other individuals. In Buttes, the disputed agreement was political because it wasn't brokered by law, but rather through negotiation, diplomacy, and the use of force. But here, officials handed over Mr. Rahmatullah, it is alleged, and we proceed on that basis, in the knowledge that he was going to be mistreated by the United States, and that they conspired with the Libyans and the United States to render Miss Bouchard, who had never been to Libya and was 4 months pregnant at the time, and her husband, Mr. Belhaj, to incarceration in Libya. Now, although this involved arrangements between states, it was not a state-to-state transaction in either the Buttes or the Shergill sense. What was being discussed and agreed was the fate of individuals, and it was being discussed and agreed by individuals answerable to municipal law and under a framework of law. So a distinction, as I said, can properly be drawn between horizontal and vertical transactions. The former are governed by municipal law, the latter are not. It's put pithily by Lord Oliver in a slightly different context in Tin Council, at volume 8, tab 58, at page 499, MS 4166.
MS?
4166.
Thank you. Yep.
There is under E the principle of non-justiciability. It's axiomatic that municipal courts have not and cannot have the competence to adjudicate upon or enforce the rights arising out of transactions entered into by independent sovereign states established between themselves on the plane of international law. And then you see the two citations of two cases we've looked at.
Yep. Thank you.
But furthermore, there is nothing in these claims that trespasses upon the exclusive domain of the executive and thus offends our notions of separations of power in a Shergill sense. That the court might be required to pass critical judgment in respect of foreign states in the course of determining a personal injury claim under private law tells us nothing about its constitutional propriety. Here there is a confusion between comity and competence. This is not a case that seeks to challenge, for example, a decision to enter a treaty or a decision to go to war, or challenging the recognition of foreign states, nor is it a case that seeks to dictate foreign policy. If a contrast were needed, see the relief that was being sought in Al-Haq. I mean, albeit a discretionary case, and I'm going to draw a distinction in a moment. But by way of illustration, see Al-Haq, volume 4, tab 35, MS 2811 at paragraph 8.
Yeah.
And you'll see that at 2814, the relief under paragraph 8 that's being sought.
Yes,
The greatest respect to those in that case, that paragraph, Shergill provides an answer to that paragraph.
Understand.
Is one part of your claim, or one part of the claim in the Rahmatullah case in respect of unlawful detention in Guantanamo?
No.
Could it be?
He wasn't taken. He wasn't taken to.
He wasn't taken there,
to
he was
Guantanamo.
there.
Grave.
I was supposing he had been.
He's in.
Baghdad.
Yeah, all right, wherever.
Yes.
Could there be a claim? If there were a parallel case where someone was taken to Guantanamo, could there be a claim in respect of unlawful detention?
Yes, there could. And
So
Lord
we would
Phillips,
have to adjudicate upon whether Guantanamo was legal under United States law.
Yes, if that's required to give effect to a domestic right, and Lord Phillips makes that distinction in Abbasi. If you're simply seeking discretionary relief, that's going to be a very good reason why the court's going to say no, or maybe a very good reason why the court could say no. It's going to depend on context. But if you're there as of right, and if you have to require, if your claim is for trespass the person, false imprisonment, and it requires consideration of that, then yes. This is not about embarrassment, and I'm going to develop it. It's not about embarrassment at foreign affairs. It's not about the courts not being equipped to deal with issues of international law if they have to.
Lord Phillips actually says that in Abbasi, does he?
He makes the distinction with cases as of right. Can I take my lord to Abbasi?
Yes.
If I may, because I'm going to seek to identify that even in cases without a domestic foothold, our courts have been at pains to emphasise there may well have been a difference if a case had a domestic foothold, even in those category of cases.
Is this all still part of your point 3?
I think
or are you being taken out of your...
No, well, that will touch upon that. I'm still on point 2, right. Which is political in the Shergill meaning.
Yep.
So perhaps I can give an example so that we can identify what's justiciable and what's not. Assume that the United Kingdom and Libya enter a treaty and under that treaty they agree to cooperate in counter-terrorism, and assume that's a treaty that's not incorporated into English law directly. Now assume that the officials of the United Kingdom purport to act under that treaty by conspiring with Libya to render an individual from country A to be interrogated under torture in Libya. Now, there are certain aspects of potential claims, some of which will be justiciable, some will be non-justiciable. Let me start off with some that under a Shergill analysis may be considered non-justiciable. A public law claim seeking to challenge the right of the United Kingdom to enter that treaty would fail.
Yep.
Because it would require the courts to review the right of the executive to enter into an international law treaty. That's separation of powers. Assume that a private law action is brought by a victim in this country, but that the legal case is premised entirely upon an allegation that it was negligent for the United Kingdom to have entered the treaty. Again, that allegation would be non-justiciable because it's based purely upon an impeachment of a decision to enter a treaty. However, there would be nothing that would preclude the court from determining a civil claim against Her Majesty's government for conspiring to torture, with Libya to torture, where that claim is based entirely upon municipal law. Even if the acts were only done because of the existence of a treaty, they don't require the court to assess whether the treaty was valid or whether the acts were done pursuant to it. The acts that are impugned are the acts of the relevant officials governed by municipal laws. The treaty couldn't relieve the officials of the obligations under municipal law. And it's under that rubric, entirely justiciable, that the court would adjudicate it. And that's, we say, entirely consistent with Lord Wilberforce's analysis in Buttes and the stress that his lordship gives to the certain transactions on a state-to-state level. Can I take my third point, if I may? That these cases are indistinguishable from many cases routinely determined by our courts, and that the requirement to find tortious conduct by a foreign state is irrelevant. As my learned friend yesterday made plain in her submissions, under state immunity, but the point is equally as good here. The justiciability of the respondents' claims is underlined by the fact that they are analytically indistinguishable from the myriad of cases in which our courts and tribunals routinely make findings about the acts and omissions of foreign states, including the legality of those acts. The governing principle in these cases is that courts will ordinarily examine the acts of foreign states, including their legality, to the extent that it is necessary to give effect to a properly grounded claim brought as of right before it. Let me again give you three hypothetical examples to drive that point home. Now, the first one is this. Let us assume, and this is not entirely theoretical, but let us assume that the government wished to rely upon evidence obtained from Mr. Belhaj in SIAC proceedings. And let's assume it was said that the evidence was obtained while he was being tortured by CIA agents in Bangkok, on the jet, and by Libyan agents in Tripoli. Now, there could be no question about the appropriateness of SIAC adjudicating upon the admissibility of that evidence.
Understood.
Anything Mr. Bristow, on behalf of the Foreign and Commonwealth Office, said about the damage to foreign relations would be irrelevant to the question as to whether or not it was justiciable and whether or not the subject matter fell within the constitutional competence of the court. And the same point, precisely the same point, would be made if that evidence was sought to be relied upon in criminal proceedings. Can I just take you very briefly to Lord Bingham in A, because it was urged upon the House, in A number 2, it was urged upon the House to be mindful of the impact that such an approach might have. We see that in volume 5, tab 45. And if we could just turn up, please.
Page
3280. Paragraph 50. I'm not impressed by the argument based on the practical...
Paragraph 50, did you say?
50, yes, 50, my lord, on 3280.
I'm not impressed by the argument.
Based on the practical undesirables of upsetting foreign regimes which may resort to torture. On the approach of the Court of Appeal majority, third-party torture evidence, although legally admissible, must be assessed by SIAC in order to decide what, if any, weight should be given to it. This is an exercise which could scarcely be carried out with investigating whether the evidence had been obtained by torture, and if so, when, by whom, in what circumstances, and for what purpose. Such an investigation would almost inevitably call for an approach to the regime which is said to have carried out the torture. Yesterday, Mr. Eadie suggested that you needn't worry about this, because this was all decided not under the common law, but under the House of Lords taking an approach to Article 15 of the Convention. My lords, my lady, not a bit of it. See paragraph, for example, see paragraph 52 over the page at 3281. I accept the broad thrust of the appellant's argument on the common law. The principles of the common law, standing alone, in my opinion, compel the exclusion of third-party torture evidence as unreliable, unfair, and offensive to the ordinary standards of humanity, decency, and incompatible with the principles. See, to like effect, Lord Hoffman, paras 95 to 96. Lord Hope, paragraph 112. Lord Roger, paragraph 137. Lord Carswell, paragraph 152.
Yep.
Indeed, this is the approach that SIAC regularly conducts. And on occasion will make eye-watering criticisms of foreign states. There are examples in the bundle. I'm just going to give you a reference. There's no need to turn it up. But see, for example, in context of Libya, volume 5, tab 40, the case of AS and DD. Now, there is no principled distinction between SIAC or a criminal court making findings as to whether or not a given state has tortured and in what circumstances, when and where, than the task that the court would be asked to undertake in these civil claims. I'm going to come to the dividing line with legality.
Yep.
Can I give you another example? Assume that these CIA operatives who are alleged to have tortured Ms. Butchar and Mr. Belhaj decide to come to the United Kingdom. Now, they would be liable to prosecution under Section 134 of the Criminal Justice Act.
Criminal Justice Act, which year?
Of 1988.
Thank you.
You'll find a copy of that. We don't need to turn it up. Volume 2, tab 15, MS 1889.
Yep.
Now, there would be no question in that case that the court had jurisdiction to try it. And the central issue in that case, the only real issue in that case, would be the legality of the acts of the foreign official committed on foreign soil. It would be justiciable. Not even in these circumstances would state immunity prevail.
Yep.
Now, assume a case without these named defendants, but another case in which it said that British officials have been complicit in torture. they too would be prosecuted before the criminal courts under section 134. And there could be no question at all that it would be rendered non-justiciable merely by the fact that the court would have to consider the acts of the other foreign defendant.
But, I mean, this is not, is it a very good example, because surely the criminal jurisdiction arises from states' consent or from customary international, from states' consent, doesn't it?
Well, my lord, that is certainly a distinction, but not for the purposes of asking, does this fall within the constitutional competence of the court? Is this something a court is able to do? Is this something that's so alien to judicial process, which is what we say is really what Butts is addressing, and what the court is addressing in Shergill? Is it alien to judicial process? Is it contrary to the notions of separations and powers that you can't grapple with it? And we show that precisely the issues arising in this case could be grappled with in another court. And if what is being sought is an immunity, and that's essentially what's being sought by my learned friends, if it's an immunity, immunity must attach to the subject matter of the proceedings. It can't vary according to forum to forum. And my lords, my lady, that is driven home by my third example, because the Human Rights Act shows us that these kind of cases are justiciable, and indeed, in Mr. Rahmatullah's case, will be justiciable, because his Article 3 case proceeds. My learned friends accept that foreign act of state doctrine does not bite upon his Article 3 case. So his Article 3 case will require detailed consideration of what occurred to him after his transfer to the United States, his mistreatment, his where, when, and how. Oh, and I beg your pardon, and Article 5, also not said to be touched by foreign acts of state. Now, if Mr. Belhaj had been, rather than what is said to have been the intelligence that was passed to Libya, if in fact Mr. Belhaj was initially in the custody of the United Kingdom and he'd been passed to the Americans in Bangkok, then similarly he would have had a claim that could be premised on the Human Rights Act, and exactly the same subject matter in that claim would fall to be determined as the subject matter of his private law claim. And there would be no argument at all but that it was justiciable. Now, if the test is that identified by this court in Shergill, of constitutional competence touching upon the separation of powers, it is illogical to say that it is just a court can properly determine precisely the same facts under the Human Rights Act, but is outside its constitutional competence to consider it under the common law. My lords, these courts have, if I may be just forgiven at 1 o'clock for a polemic, these courts have always prided themselves on the protections in common law running ahead of those incorporated in the Convention. That would turn it on its head. And just when we come back, I'm going to show you, or at least identify for you, 2 Strasbourg cases in which they've done exactly that, they've gone through exactly that process without any of the difficulties, or without any of the insurmountable difficulties that my learned friends urges upon you.
Are you going to deal with Noor Khan at some stage? Are you going to deal with Noor Khan?
Yes. Yes.
How are we doing in terms of time?
Well, my lord, I think realistically, we are going to finish, both my learned friend and I are going to finish all the respondent submissions by the close of play. I might have been slightly optimistic to think that we're going to have a start on the interveners.
You better avert your optimistic position if you possibly can.
I will do my very best, my lord.
Thanks very much. We'll resume again at 2 o'clock. Court's now adjourned.